obtained those orders ex parte. The matter was mentioned before the Honorable Orenge on 29th of November, the year 2018, in which both parties agreed by consent that that application for protection orders would be heard on the 11th of December, the year 2018. Contrary to what Council tells you on the record is in Honorable Orenge's file, the matter was listed, but the applicant failed to turn up to prosecute it. So the situation was, here was an applicant who was enjoying ex parte orders. When the matter is scheduled for inter partes hearing, they failed to turn up. That is the circumstances under which the Honorable Orenge dismissed the application for want of prosecution. On that same day, that is 11th of December 2018, the applicant made an application to reinstate the suit that was dismissed by the Honorable Orenge. We appeared before the Honorable Orenge on the 19th of December to argue that application for reinstatement. Yes, Your Honor. More importantly, on 19th, the applicants asked the Honorable Orenge to issue interim orders pending his ruling on the restatement of the suit. The Honorable Orenge declined that request and instead directed that he will issue a fully considered ruling on the 4th of January, the year 2018, which is now just 1 week away. By revisiting that issue before Your Honor, when even my Lord has no jurisdiction, what the applicants are effectively seeking to do is to preempt the ruling, or to short circuit, I don't know the word, that may come from the Honorable Orenge. You're being asked to act without jurisdiction, but even if you are wrong on the jurisdiction, what you're effectively being asked is to preempt the ruling that the Honorable Orenge will make. What the applicant didn't also disclose to you still on this matter is that on 19th of December, they filed yet another suit. Yes. Before the Honorable Nyaloti at the Resident Magistrates Court, seeking the exact same orders they are now seeking from you. Yes, on the Chief Magistrates across the road, my Lord. So that suit was filed at the certificate of urgency. It was placed before the Honorable Nyaloti. And we appeared before the Honorable Nyaloti on 20th of December, where we told the Honorable Nyaloti that one, the suit was sub judice to the extent that there was an exact same suit before Honorable Renge. And number two, where we told the Honorable Lord, just like we are now telling my Lord, that the applicant was again trying to preempt the ruling before the Honorable Orenge. And we also told the Honorable Nyaloti that even as we were appearing before her, the applicant was simultaneously, at that moment as we were on our feet, another counsel was on their feet in the High Court at Meru, now in the file before my Lord, seeking effectively, and I'm using this word deliberately, my Lord, effectively the same relief. The only difference being what I usually call legal sophistry, because in the case before my Lord, the matter had been structured as one of protection of matrimonial property. But in the two suits before the magistrate, the matter had been structured as one of protection from domestic violence. But when you sift through, when you read the actual reliefs in the three suits, the substratum of all the three suits was that the applicant was seeking to have exclusive user and possession of the so-called matrimonial homes in Runda and in Meru. When it transpired that was the situation, that the Honorable Nyaloti was faced with a suit touching on the same subject matter, same parties as was before Renge and Justice Gikonyo in Meru, the court was so incensed that the order that was made was that this file should be taken to the registry. That's the order the Honorable Nyaloti made, because she considered the matter abuse of process in view of the fact that it's posed, or rather I've explained to the court. Today morning, my Lord, we were served with the mention notice for the case before the Honorable Nyaloti, which we found curious because the order was that that file be taken to the registry. We appeared with my learned colleagues before the Honorable Nyaloti, and they made the same exact application they are now making before you for a protection order today morning. Yes, Your Honor. The Honorable Nyaloti declined to intervene as the applicant would have wished, and told us in any event, since the Honorable Orenge was seized of the matter, she would need, as a minimum, to requisition for the file before the Honorable Orenge. Your Honor, I've just addressed you on three suits. The correct position is that there are 4 other suits between these same parties, making a total of 7 suits. I don't know whether I recall some of them off my head. Maybe my Lord may want to hear the numbers for some of them. There is the suit number 1260 before the Honorable Nyaloti. There is suit number 1044 before the Honorable Orenge. There is suit number 412 in the commercial division of this court. There is a divorce. The same properties, yes. There is
company properties, you know. All these matters that we've been articulated. Right.
So, Your Honor, I said there are 7 suits. I had mentioned some before I was interrupted. I was to tell you there is a divorce course in Meru. Number 26 of the year 2018. There is a civil suit number 9391 of 2018. 9391 of 2018. There is a civil, the 9391 is before the Chief Magistrate Court. There is civil suit number 138 of the year 2018 before the High Court, Commercial Division.
138.
Yes. So, Your Honor, so that I don't take much of your time, our position on the so-called protection order is 1, you have no jurisdiction, in summary. And number 2, if they have failed to persuade the Honorable Nyaloti and the Honorable Orenge who have jurisdiction, what they should be doing is to lodge an appeal against you, or rather before you, or a review of the decisions made by the Honorable Orenge and the Honorable Nyaloti. My Lord has no original jurisdiction because of an express bar to be found in section 24 of the Protection Against Domestic Violence Act. Having said that, my Lord, I can now address you.
Just before trial.
Yes. All these are suits filed in the last 2 weeks. Yes. My Lord was saying in summary, this court has no original jurisdiction. Okay.
The commercial division matters.
It is a fight over these same companies and properties that are the subject of now, for purposes of the matter before you, matrimonial property, for purposes of the problem before Honorable Orenge and Honorable Nyaloti, protection against domestic violence. Called Pamela Gerono, who is a lady that is fully able and of means. So it is not, again, clear, at least not to us, how the applicant can use a third party's child, especially when that third party is not under any disability, especially when the applicant has not produced before my Lord an adoption order showing that they have adopted that child and therefore assumed parental responsibility for them. And in short, nothing turns on the children, other than, it's tempting, my Lord, when we mention children, people get a bit more jittery and natural human sympathy. But we're saying that is maybe the human nature being abused here, so that my Lord will have undeserved sympathy. My Lord, in our affidavit, at paragraph 6G, and my Lord, if I'm mentioning paragraph 6 a lot, it's because in paragraph 6 we have set our summary. The structure of our affidavit is, we have told you in summary what is our. So after paragraph 6, the other paragraphs are just elaborating and giving my Lord their next choice. So if you go to our paragraph 6 of our affidavit, there's a subheading there, style summary. And for now, I only address my Lord on that paragraph 6, because then the other things are in their next years and they're elaborated in the other paragraph. So the paragraph 6, event G, and in that paragraph, my Lord, we've told you, this, it's easy to pose as a victim, as someone in distress, the talk of a damsel in distress. And we are telling you, the applicant before you, someone in distress, so that we should actually be bothering my Lord during vacation. She owns, as explained here, several properties in high-end estates in the city. We have annexed some of the title documents. My instructions are actually that she owns more than 200 houses in the Republic of Kenya. So she's not this desperate damsel in distress that my Lord is being invited to have pity on. But if I am wrong, my Lord, and we refer to Exodus 3 there, by our own account, and by our own submissions even before my Lord, this is someone who affords to have 10 million shillings in cash in the house. Anyone who can afford to have that kind of money in cash, whether we call it relief or whatever it was called, is not the sort of person, my Lord, who should be wasting your time here, wasting Orenge's time, wasting Nyaloti's time, and all these other 4 judges to be allowed to live in one specific house, whether it's in the name of matrimonial property or whatever. We will come at the right time and brush the issues of the full hearing. My Lord, we have told you in paragraph 8, another H, 6H, that these proceedings, just like the other 7 suits, are merely closed. The court process is being abused as a means of expropriating private property. The reason we say that is to be found in paragraph I, and we're only mentioning I if we are wrong on the preliminary issue, whether there is a marriage. The applicant has filed a huge battle before my Lord. The only thing she has told you, which is easy, I'm finishing actually, my Lord, because yes, and I'm saying actually it's the last point I'll tell you. The applicant has a huge battle telling you listing properties that she tells you were acquired during what we say is no marriage. What she has not told you, whether in her affidavit or in the application itself, is a specific contribution to the acquisition of those properties. What she has not told you is that most of those properties were actually acquired even long before the date she claims to have entered into this customary marriage. And in short, it is not enough to allege marriage, which is, in our case, is a void marriage, and then say, oh, property. For all those many reasons, my Lord, we are asking you, just like we asked the Honorable Orenge, the Honorable Nyaloti, Justice Ongeri, Justice Gikonyo, not to grant this application. It's a parting shot. There must be a reason why all these judicial officers, of all these matters, have not been persuaded to grant the relief.
We are saying the same properties you said about as restraining and transfer, blah, 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 in respect of those accompanying property where is a shareholder. Right. Okay. So I said that's you bring the property of accompanying matrimonial property.
We were seeking, when we were putting these prayers, we were seeking in any interest that they got, in any property that she has interest, and the property might be deemed or might be wasted. We are seeking on the same. We are seeking
so at the end of the day, the court will share out this property, right? And the court share this property owned by a family at the conclusion of the case.
At the conclusion of the case, we'll get to determine on.
No.
Right.
The intention is to have this property acquired sharing substitution might be divided. That's what section says.
That is the essence.
Proper says.
Yes.
I'm asking at the end of this case,
right?
The court then share out property held by family.
The court now will look into the shareholding of these parties and look at who deserves not to have anyone to call home. That is where their books were. That is where we found their belongings. We've been told by counsel that we didn't find any passports or documents that relate to the children. Your Lordship, the report that we made, that was made by the two deputy registrars, paragraph 16 of the said report said, and I read, there was also a mini kitchen and bar attached to the master wing. There were cutlery, utensils, child school report card for Sharon Term 1 2017, for Alliance High School and Cooperative Bank deposit slip for 790,000 deposited by the respondent. Your Lordship, if we are being told that the respondent, there were no documents there that can link the children to the house, it's completely misleading. That is the house that these children have not home. Their books are there. Everything else is there. They are opening school on 2nd. Your Lordship, if we don't have interim relief, the children suffer the jeopardy of not reporting to school. These are the child that is in Australia that is being denied, that is, it was never been in Australia. Your Lordship, we have in our affidavits indicated that actually the respondent, the applicant, have been visiting this child in Australia. He lives there, and if we don't permit him to go back and collect his belongings and go back to school, he suffers. Right.
Will you be proceeding with the other matter before the court?
No, if need be, we'll have this matter consolidated if we will have, because
subject is the same.
Yeah. In some of the suits that we've been told, we have left the respondent to live. We are not in any dispute wanting to go there.
The subject is the same for two suits.
The subject is we are seeking protection orders, which are the same in both.
My Lord, so that we avoid wasting your time, because we could actually take a 10-minute break. We bring you the two suits. You see, it's the same. And the truth is, what the applicant ought to have done. No, because he's denying it is the same suit, and it's the exactly same relief.
I am not denying. I'm saying that
the facts are the same.
Yes, what I'm saying is that the respondent has not been in that house since April 2018. He has not stayed there. This is a place, this is a house where
instead what has been on temporary basis before the will is delivered, and the magistrate now wait for the ruling.
And for the record, that was requested and declined by Orenge.
Which is coming forth. Now, as you are waiting for the ruling, you realize that somebody had taken advantage of the info and proceeds to evict.
Yes.
And then you decide to go now to lodge in the different suits, seeking for the same protection.
Look, we filed it and it was taken to the duty, still application, and it was filed, it was taken to Honorable Inyalosi.
So the duty is very hard to see that the suits.
It was a misleading application, the Lordship.
It's a suit.
Yes. So we were seeking actually that during the pendency of, as we await for a ruling, at least we have. Now, when this matter was dismissed for want of prosecution, the respondent with an non-assailant, almost 100 men, went to the applicant's house and evicted her. Your Lordship, that necessitated us going to Honorable Nyalote. When we came on Friday, we were told that there was this matter here now, that we had to wait for deliberations and a site visit to the house, which we did and went.
So what came first? This matter or Nyalote's first?
They were both coming on Friday, and we
Friday.
yes. So today we were before Honorable Nyalote. Now Honorable Nyalote, she's leaving the station. She's been transferred. She's not hearing matters today.
So what did you file before Nyalote?
What we found is that she referred us.
No, what you filed?
What we filed is to seek protection.
Same one before him?
Seeking protection, yes, because now she has been evicted and she still continues to be threatened. She still feels a threat in wherever she is, that she's being followed by the respondent. She's seeking further protection.
So you are seeking further protection?
Yes, protection orders. No, he didn't refuse to give us. The matter was, Honorable Renge gave protection orders, Your Lordship. Yes, for what to prosecute. Yes. Now, after they left, that is when, during that period, the respondent used that duration to go and evict the applicant. We filed a miscellaneous application to have the
It's a separate suit.
It's a separate suit with a separate number, my lord.
Yes,
Separate suit.
yes, seeking protection as we wait for the ruling. Because now there is imminent danger.
Why did the same court give you this orders?
The duty magistrate was at that particular time. The matter was referred to Honorable Nyalote.
What I'm asking.
Yes.
Crimes in which protection orders were granted before him.
Right.
So this one.
Yes. So it starts at page 26 there. Then if you go to page 30 is where the motion itself is. Page 30. Oh. Perhaps I can even ask my lord to look at this one. Yes. So, my lord, if you read that notice of motion, you'll find in Roman number 2, Roman 6 and 7, and even prayer number 4 and whatnot, the so-called protection order was actually in effect, and
which we made a report, and this so-called visitor in the construction of the house had even the audacity of building and enshrining the names of the children on the walls and ceilings, it's laughable to call such person a visitor. Very wrongly should treat these parties with the respect they deserve. Going back to how we brought ourselves into this court with regard to the protection order. Your Lordship, we were before Honorable Orenge, who, unlike what counsel said, that we were unable to persuade the court to grant any orders. Your Lordship, orders, protection orders were granted, and they were in place. When that application was coming up for inter partes hearing, Your Lordship, you've been told that this matter was not cost-listed, was cost-listed. Your Lordship, there was a cost list. We have a cost list that shows this matter was not cost-listed on that day. What was cost-listed is the number and other parties which are not party to that suit. In the process of us ascertaining and clarifying why there was wrong caption of the party that is the suit, we went back to court at around 10. We found out that this matter has been dismissed for want of prosecution. We were in court, contrary to what we are told, that we are never in court to prosecute these matters. There were other matters that had come even days earlier. We were already in court. Counsel is aware of this. Yes, we were in court. No, we were in the registry trying to clarify why the matter is not cost-listed, and they're trying to get the file to court. That is the essence. So, in counsel saying that we were never in court, it's absolutely misleading. Now, to the aspect of us moving to Honorable Nyaloti, we were indeed, yes. What is before Orenge is that we filed to have the suit reinstated. Now, the ruling is coming up on 4th January 2019. In that duration that this matter was dismissed for want of prosecution, the respondent has a habit of maximizing damage during that limit. That is when the eviction happened. Your Lordship, could we have waited till 4th January to have potentially loss of life, and we have a leeway in which we can seek for protection of life and property and such like? That is why we went to Honorable Nyaloti to seek that we be given protection as we await. There's no protection of property. Protection orders against, because now an eviction had happened. What was before is protection, yes, protection against domestic violence.
No, that's not correct, my lord. What was before, and this is why I talk of legal sophistry. The order that was being sought from Orenge in the nature of a protection order, which I think might even be annexed in the applicant's own case before Orenge, was an order to allow, I think it's at page, I'm trying to open it, my lord. It was an application to enable the applicant to live in the my property I'm looking at page 30 of the motion before my lord. No, of the applicant's case before my lord. The application dated, or rather it stamps 25th October. This one, the one of the applicant. Yes, the applicant's bundle. Page 30. Yes. I saw something styled that there, but it's not paginated correctly. So that even if I was wrong in all the submissions I've told you, it is an abuse of process for the same litigant to be seeking the same protection order before 3 courts concurrently. Because as it were now, unless the court exercise caution, we run the risk of 3 different decisions. One by Orenge, one by Nyaloti, and one by my lord. It's clearly an abuse of process. If the wanted audience will give, your jurisdiction will be upheld or reviewed, and there is no motion before my lord in appeal or in review of the decision, orders, and directions made by the Chief Magistrate's Court as decided by Orenge and Nyaloti. That brings me, my lord, to the application now before you, which is the application supposedly for protection and preservation of matrimonial property. We have filed, my lord, before you an affidavit. I don't know whether it's on your court file, but it is the one with up to number 20. I don't know whether my lord has it. Perhaps so that I'll be brief, my lord can just flip through it. And in that response, my lord, we have taken the view number 1 under part B, that proceedings for protection of matrimonial property are based on the presumption or proof of a valid marriage in the first place. Unless my lord is satisfied at this stage on a prima facie basis that there exists not a void, not a sham, not a pretended or alleged marriage, but a valid, legally valid marriage. Unless there is prima facie evidence of the existence of that, the application before my lord collapses on arrival. In the affidavit that we have filed before my lord, we have annexed to that affidavit exhibit number FML1, a copy of a marriage certificate. It is exhibit number 1, my lord. It is FML1, the very first exhibit to our replying affidavit. It's number 1 on the separators. And that document shows, my lord, that the respondent has, since the date appearing on that certificate, which I think is 2005, if I'm reading right, up to date, the respondent is party to a statutory or monogamous marriage with a different woman other than the applicant. If we take it on a prima facie basis, my lord, that the respondent is married to a different woman under a statutory regime that does not permit polygamy, then the implication that follows from that is that the applicant, now before my lord, cannot be heard to say that she went through an African customary marriage with the respondent. Because even if we were to assume, my Lord, for argument's sake, that she went through all the rites and ceremonies and rituals of Meru customary marriages, those rituals will not confer to her the status of a wife when there is a pre-existing monogamous marriage. So even if we assume, which is denied in our affidavit, the respondent has denied all these ceremonies supposedly celebrated to make an African customary marriage, even if that marriage were to be celebrated by the chairman of the Jurincheke itself, it will still be void in law, pursuant to sections 6, subsection 2, section 8, subsection 1 and 2, and section 9A of the Marriage Act of the year 2014. The structure of our Marriage Act is that a party to a monogamous marriage cannot celebrate another marriage of whatever form before the dissolution of the monogamous marriage. There being no valid marriage, the question of matrimonial property does not arise. My Lord, if I'm spending too much time on this issue of monogamous marriage, it's because I hope we all both the bar and bench realize the implications. The President, my Lord, would establish by granting the application now before you. One, my Lord would have amended the Marriage Act to say that a Christian marriage or a civil marriage is either polygamous or potentially polygamous, contrary to the express wording of the statute. The policy question of whether men or women who are parties to monogamous marriages can enter into customary marriages is a matter to be decided not by the court, but by Parliament. For now, Parliament has, through Section 6, 8, and 9 of the Marriage Act, decreed that it is impossible. In our affidavits, paragraph 6, subparagraph B, and through exhibit number 2 of our affidavit, we have shown, my Lord, that the applicant herself, now forget the respondent, the applicant herself was in a monogamous marriage during the periods the alleged cohabitation and civil, or rather customary marriage was celebrated. And we have put before my Lord exhibit number FML2, being a judgment by the Honorable Justice Mushelule, dated and delivered on 4th December 2015. And the effect of this decision was that the decree absolute, which dissolved the marriage between the applicant and her ex-husband, would issue in 30 days, which would mean the applicant now before you was married to a different party up to and including that January, the year 2016. So the question, my lord, how can a lady who was married to a different man file like she's done before you an application containing she was cohabiting and going through customary rites of marriage with the respondent at the same time? You have been told much about the children that are supposedly suffering. Number one, you are told one of them can go to Australia because his passport is in whatever. Luckily, we did a comprehensive site visit, the report of which my lord has, signed by 2 deputy registrars of this court. And there is no travel document of any child was found in that house. Number 2, if you go to our paragraph 6, subparagraph F, of rather subparagraph E. So it is paragraph 6, subparagraph E of our submissions, or rather of our affidavit. All the 3 children supposedly now suffering because of this misunderstanding between the parties, one of them is not actually a child, is an adult of full age. The other one is the subject of a joint custody and parental responsibility between the applicant and the third party. And that third party is the applicant's ex-husband. So when my lord is being told one of the reasons you should issue, I don't know, protection order, I don't know, preservation because of children, there is a man other than the respondent who, pursuant to decisions issued by the court, including the decision by the Honorable Mushelule that I alluded to, who has parental responsibility for that child called Sharon Langat. The third child that is being mentioned so as to invoke and